Ignorance of the law is no excuse unless you're a cop. Let's talk about it. We've all heard it before. Ignorance of the law is no excuse. It's a foundational idea in our legal system. The principle that everyone is presumed to know the law and can't use ignorance as a defense when they break it. Now, whether you're a tourist who unknowingly runs a red light or a citizen who misrepresents a statute, the message is the same. You should have known better. But what if you wear a badge? What if you enforce the law instead of just follow it? It will not come as a surprise to most of you that it turns out much less is expected of those who are tasked with doing the best they can to understand the law they purport to enforce than the expectation levied on me and you, the people doing the best they can to understand the law they're trying to follow. Yes, you heard that correctly. There's a very different standard, a wider path to be traveled, if you will, for law enforcement than there is for the common citizen. One that shields them from consequences of not knowing the law, even when that ignorance directly harms others. It's called good faith. So we're going to walk through a 3-step process by which the criminal justice system reinforces itself, protecting its agents from liability and ultimately from accountability. The result is a deeply entrenched double standard between civilians and cops. Buckle up, kids. This one's going to be hot. Step 1. Good faith as a catch-all shield for police misconduct. We all know that one of the key ways officers avoid civil liability is through qualified immunity. It's a legal doctrine that shields government officials from being sued for constitutional violations unless they violated clearly established law. Courts have said that if an officer acts in good faith, meaning they didn't know they were violating someone's rights, they're often held immune from consequences. And sure, on paper, that makes at least some sense. I mean, consider this. An officer arrests someone based on an active warrant. The officer checks the database, confirms with the records division, and follows procedure. Only later does anyone realize that the warrant had already been served and it wasn't properly cleared from the system. The arrestee, well, he sits in jail for a long weekend and he gets arraigned the following Monday. And all of this was based on a mistake that probably some clerk made, a serious harm, and someone should pay for that, right? But the question is, should the officer personally pay for that after having done everything within his power to make sure it was accurate? Probably not. It was a clerical error. The officer genuinely believed the warrant was active and exhausted all efforts to make sure he was correct. Now, that's the kind of good faith qualified immunity was originally meant to protect. But fast forward a few decades, and courts have expanded that exception far beyond common sense and created something that requires an Olympic level of mental gymnastics to understand. Qualified immunity has become an almost insurmountable barrier for plaintiffs. It now protects even obviously unlawful actions, so long as a judge can imagine a hypothetical reasonable officer who might have thought it was okay. And that brings us to step 2, objective reasonableness and arguable probable cause. The standard of objective reasonableness is not altogether bad. After all, it does come to us from the Supreme Court's decision in Graham versus Connor from 1989. In that case, the court ruled that an officer's use of force must be judged based on whether it was objectively reasonable, not based on their subjective intent or state of mind. The law takes the officer's information that he has at the time and views the facts known to the officer at the time from the lens of someone else, a fictional, reasonable officer who might have done the same thing. In other words, we are forced to pretend that this ego-driven maniac who smacked the phone out of your hand isn't the person we should be focused on. His inability to respond with professionalism or curtail his unhinged emotions shouldn't matter. We have to pretend he's someone else, an objectively reasonable police officer. Now, that standard is not entirely unreasonable when analyzing split-second decisions in tense situations or where it's not an obviously unwarranted use of force pursuant to the Graham factors. But this standard has been imported into the qualified immunity analysis, where it does a lot more damage. Now, instead of asking, was this a constitutional violation, courts instead ask, could a reasonable officer thought this was legal? Even when someone's rights were clearly violated, qualified immunity often shields the officer because their mistake was deemed reasonable. And it gets even worse when it comes to arguable probable cause, a concept that further protects officers from civil liability in false arrest and unlawful search cases. Even if you were arrested without actually actual probable cause. Courts may uphold the arrest if an officer could have reasonably believed they had it. That means your constitutional rights hinge not on what happened, but instead on what a hypothetical officer might have believed, even if they were wrong. Together, these standards work to shift the focus from whether a right was violated to whether the violation was understandable. It raises the bar for civil rights plaintiffs to nearly impossible heights. And it also creates a legal feedback loop where your rights aren't clearly established unless a nearly identical case already made it through the same legal obstacles where the plaintiff prevailed. And that leads us to the final step, step 3, using the good faith exception to allow evidence to convict and block accountability. Now, let's say an officer makes an unlawful stop or a search, but claims they didn't know they were violating your rights. Under the good faith exception to the exclusionary rule, courts may still allow the evidence into trial if the officer's mistake was reasonable. Let's look a little closer at a couple of landmark cases that got us here. Let's start with the United States versus Leon from 1984. That was the birth of the good faith exception. In Leon, the police in California obtained a search warrant based on a tip that Leon was involved in drug trafficking. They found large quantities of illegal drugs during the search, but later a judge determined that the warrant lacked probable cause, meaning it never should have been issued in the first place. And the legal issue at play there was under the Fourth Amendment, normally evidence obtained through an unlawful search is excluded from trial after a motion to suppress is filed by the defendant. So Leon argued that the drugs should be thrown out because that's the way things are supposed to work. But the Supreme Court said, no, Leon, we're creating what we now call the good faith exception. The justices held that since the officers relied on the judge's warrant in good faith, the evidence should still be admissible, even if the warrant was technically invalid. So the key takeaway from this case is that evidence gathered in violation of the Fourth Amendment can still be used in court if the police were acting in good faith, believing their actions were lawful, similar to our hypothetical earlier about the police officer executing what he thought was a valid warrant. Now, this marked a major shift in Fourth Amendment jurisprudence, focusing less on protecting individual rights and more on whether police made an honest and understandable mistake. And the second case we're going to look at is called Heien versus North Carolina from 2014. And this good faith exception is about misunderstanding the law itself, not about whether there was probable cause for the search warrant. In this case, Nicholas Heien was pulled over in North Carolina because one of his brake lights wasn't working. The officer who pulled him over believed that this was a traffic violation. During the stop, the officer asked to search the car and found drugs. Heien was arrested and charged. Well, what's the big deal, you might ask? Well, it turns out the North Carolina law only required that one working brake light be present on the vehicle, not two. So the stop was based on a misunderstanding of the law and not a misunderstanding of the facts. So the legal issue at play in this case was, could an officer's reasonable mistake about what the law says still justify a traffic stop under the Fourth Amendment? Common sense would say, no, sir. No way. Needs to be thrown out. But that's not what the Supreme Court said. The court ruled that a reasonable mistake of law can still give rise to a valid traffic stop, since the officer genuinely believed the faulty brake light was a violation, and that belief was reasonable. The stop was upheld, and the search was legal. The key takeaway here is the good faith exception now applies not just to factual mistakes like in Leon, but even to misunderstandings of law itself. So the idea that ignorance of the law is no excuse or ignorance of the facts is no excuse, neither of those things apply to the cops. As long as those misunderstandings are deemed reasonable, they get a green light to proceed. Now, why do these cases matter? Together, Leon and Heien expand the good faith exception to a point where officers can violate our constitutional rights and still get to use what they find against us, so long as the court later decides that their mistake was reasonable. It takes the Fourth Amendment from something that was guaranteed in the Bill of Rights and turns it on its head. It renders our Fourth Amendment protections as conditional, especially for those among us who don't have the means to challenge it in court. And when this logic gets layered into qualified immunity and arguable probable cause, it becomes part of the system that shields law enforcement from both criminal and civil consequences, no matter the impact on our rights. So the illegal stop stands and the evidence gets used, and now you're convicted. And you want to go sue for false arrest or malicious prosecution, but guess what? That conviction, in most cases, will become a legal barrier to your civil lawsuit. Courts treat the conviction, even one based on unlawfully obtained evidence, as a superseding cause. In other words, they say that the judge or jury convicted you, and that breaks the chain of causation between the officer's actions and your harm. And it doesn't help the matter that the standard for proving someone guilty in a criminal action is proof beyond a reasonable doubt. And so this imaginary presumption of innocence is now flipped in the other direction, and now you have a presumption of guilt to overcome at the appellate level. And as you can imagine, You can't then go sue for being wrongfully arrested if a court says that your conviction proves the arrest was justified. And you can't challenge the legality of the evidence if the court says it was obtained in good faith. This creates a self-reinforcing loop. 1, officers make mistakes. 2, those mistakes are excused as reasonable or made in good faith. 3, the resulting evidence is used to convict. And 4, the conviction blocks any attempt at accountability. In closing, it's a system built to protect itself. The law tells us that ignorance is no excuse, but courts routinely excuse police officers who don't know the law they're enforcing. Through a combination of qualified immunity, objective reasonableness, arguable probable cause, all underpinned by the good faith exception, the system has built a legal fortress around law enforcement. It allows violations to happen, protects the evidence that comes from those violations, and uses that evidence to lock people up, all while making it nearly impossible to hold anyone accountable for the original misconduct. Now I ask you, when is the citizen the one who funds the salary of the police officer who falsely arrested him, the same one whose taxes funds the court, and whose eventual fines and court costs further fund the court system that rendered him a victim? When does that person get the benefit of the doubt in any of the ways I've just mentioned help shield the police officer from the consequences of his misconduct? The answer is the only time we get to pretend on behalf of the citizen is when we say things that make us feel fuzzy about the justice system, like innocent until proven guilty, or the justice system at all, or fair and impartial. That's not justice. It's just us against just them. And that's a rigged game that can't be won. And it's about time we start calling it what it is. Anyway, that's all for this one, guys. Thanks for sticking it out. I hope you got something from it. I'd like to invite you to come over to the Substack community. Check it out. It's absolutely free to join. If you would like to join on a paid tier, that's an option for you. That information is available on the landing page when you get there. I'll leave the link to Substack in the description. I'd love to have you as part of the Substack community. If you don't want to go over to follow me on another platform, or you don't want to join a paid tier, but you would like to support the Southern Draw Law channel monetarily, I'll post my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.